The first question is, how does a will affect joint assets? So I think what is meant by this is, let's say that I own a piece of property with my wife. Okay, so it's in both of our names. And my will says that, just imagine this was the case, everything goes to my daughter. Okay. Well, what would happen with the house? See, some people say, aha, see, the will says everything goes to his daughter, so that ends it. Well, the problem with that is a will only has power, only controls over things that are in my name only. So a joint checking account with a child, with my brother, with a friend down the street, my will has nothing to do with that. A piece of property that I own jointly with somebody, my will has no control over that. Okay, if we're talking about typical joint ownership, where when one person dies, the other person gets it. So just keep that critical concept in mind, because we get calls all the time. People come up to me at church or other places and say, hey, what's going to happen here, because the will says it goes to all four kids, but one of the kids is a joint owner on all the financial accounts. Well, then technically that kid gets everything, because a will only controls things that are in my name only. So it certainly is appropriate and fine to do joint ownership. It's maybe not the best way to do estate planning. There can be a lot of problems with that. Typically, it's better to have a will, have at least a revocable living trust, so that you can clearly identify, well, I want this to go over here and this to go over there. But just remember, a will, only things in my name. And whether we're talking about a trust, a will, it doesn't matter. The ownership is going to trump any type of estate planning. So I might have shared this. I don't know if I did this in a video or maybe just in some live seminars in front of groups of folks. But there was I want to say it's like maybe 85 years old. This is a year or two ago. And he got remarried late in life. But he told his kids, hey, don't worry, everything's going to you. And so I think he had maybe a $400,000 IRA. And he dies like 2 months after he gets married. And so the kids go, okay, hey, it's ours. All right. The will says it goes to the 4 kids. And the now new widow says, wait a minute, his assets are mine. There was a $400,000 IRA. Just assume that's all that there was. And what he had written on the IRA, as far as beneficiary, is he said, per my will. Well, that's meaningless. Okay. So if it doesn't say who it's going to go to, then the default rule is it goes to your spouse. So you can have all the wills, all the trust in the world, but if you don't have things properly titled as far as legal ownership, then the best will, the best trust may end up doing you no good. So hope that answers this question of